Hey everybody, Nick Wooten again, Consumer Trial Lawyer Academy. Thank you for tuning in. Appreciate you taking some time out of your day. Looking forward to trying to bring you something else useful to your practice and to help you be a better lawyer, help you get better results for your clients, help you get those verdicts that I've gotten in the past that help you gain some notoriety in your community and help you deliver justice to your folks. So today we're talking about what do we do for trial planning. And at this point we're assuming you've survived summary judgment, you've got a trial setting, and you got to plan what you're going to do. So trial planning is a pretty broad topic. You have everything from taking care of where are you going to stay if you're trying a case out of town. Got to make arrangements. So someone's got to rent some hotel rooms, rent a conference room, or you got to get an Airbnb or long-term apartment rental, something like that. Things you got to think about. You know, it's going to make sure folks got food and drinks and wherever you're staying, so that you know you're not constantly stopping for Uber Eats or whatever. Those logistical things you have to think about. You know, for me, coming to Chicago for a long time, I was very fortunate. I stayed with my co-counsel and local counsel. He essentially had an extra bedroom, an extra closet. I kept a couple weeks worth of clothes there. I could come up on a flight with a backpack, catch the Blue Line out of O'Hare, hop off at Division Street exit, walk to his condo. I could stay there as long as I needed to. It was a super easy setup. Made life super simple. Tried some cases like that together. Practiced that way for a number of years. It was really easy. He retired. Great for him. Some days, you know, we all kind of wish we were doing something other than working our rear ends off. And so we had to come up with a new plan. So we tried a case in the summer of 2023, and we just rented an apartment for a month, basically. And, you know, what you think about when you start talking about trial planning is not just, hey, I'm going to be at the courthouse for these days of trial, but you also have to block time beforehand to get ready. And so, you know, for us, we blocked it from the end of our, this is the way we normally do it, or I normally do it. I go up the day before the pretrial hearing. And that's when I'm checking in to wherever I'm staying. And that's when I'm, you know, moving in my suitcase and unpacking. And that's when I'm getting food and drinks in the place or whatever, if I'm in charge of that, or it's being delivered if someone else is in charge of that. And, you know, I'm getting my notes together for the pretrial hearing. You know, we've got that pretrial process, do a separate video about, but essentially there's a ton of work that goes into that pretrial process, and that's for materials that are due, you know, 60 or 90 days prior to the actual pretrial hearing. But when we start talking about trial planning, we're talking about the actual execution of the things that lead up to and the actual, you know, beginning of the trial, and then actually the trial itself, right? So all those things are steps you have to take into this process. And, you know, we come up the day before the pretrial. We've got our pretrial materials already filed. We've got them digitally, or if you're most people that prefer paper, you've got your notebooks, whatever. And you go to the courthouse and you meet with a judge and you have your pretrial hearing, and that can take, depending on the complexity of your case, it can take a few, you know, an hour to a few days, depending on what's going on exactly. When you start talking about this level of work, you can essentially forget everything else in your practice other than this trial. forget your family, you forget your friends, you forget, everything. It's nothing but trial. And so, you'll be, when I do cases in Chicago, it's not uncommon that between the pretrial hearing, which is anywhere from 2 to 3 weeks before the trial starts, to the trial, we're doing nothing but this trial. Nothing but fine-tuning our evidence, our presentation of that evidence, our, witnesses, our jury charges, our documents. Everything is being repeatedly gone over with a fine-tooth comb, honed, questioned, and we think very deeply about whether or not we're going to do, the order of witnesses, order of evidence, order of exhibits. All those things become things that we study very intensely to improve upon our presentation to the jury. Witness juror panel questionnaires, voir dire questions, all those things are, things that get honed in the lead up to a trial. But when we get from the trial, the pre-trial hearing to the start of the trial, again, that could be 2 to 3 weeks. And in that time period, you are tightening up your opening statement. You are tightening up your examination of witnesses. You are tightening up the actual documents that you're going to use. You are reviewing every page of material that's been identified by either party. And you're doing it with an intensity and focus that exceeds even what you were doing earlier in the case. And the reason for that is simple. At this point, you know more about your case and the witnesses and the testimony than you've ever known. And as you're getting ready to present this evidence, there are essentially going to become links, ties, connections, and angles to the evidence that become apparent to you that you had not considered previously. It's only in this cauldron where you're under the heat of preparation to win a trial where things begin to meld together in ways that you have not seen or anticipated in the past. You can see things in a more focused light, because as the defendants have become by nature more focused on what they think is important and their positions in the case, and you become more focused on not only the evidence you need, but how you're going to respond to their points, all the pieces of the puzzle start blending together, and you start seeing things even in documents that you've had in your hands since day one that you didn't see until you were at this level of laser focus. And it happens every time in every case. The pressure of each side being pushed together and their conflicting positions being pressed up against each other and then tested against the actual evidence, that gives you sort of a laser hyper focus, and things begin to break in these documents, and you start to see things in a way you haven't seen them before, because things are so intently focused and there's so much pressure on the best possible presentation. And that helps you be a better courtroom lawyer. It helps you present a better case, and helps you, represent your client in a way that's going to give them the best possible chance to get complete and full justice and compensation in their claim. So, as you're trial planning, do not think that you can go in a major consumer trial, that you can go and have a pretrial, and then you've got 3 weeks to trial, and you can spend 2 weeks of that doing something else, and then you can spend a week getting ready. You cannot. If you are not intensely, fully focused, and when I say intensely and fully focused, I'm talking about 10, 12, 16, 18-hour days, repeatedly going through each step, each document, each witness, until you literally think your eyes are going to bleed. If you don't have that level of focus and intensity, in my mind, you're not doing it right. You don't have the requisite attention and focus. You're distracted by where you're going to dinner. You know, did your wife call at the right time? Did you call your kids? Whatever those focuses are, they're all distractions in that moment. You have to lock in and bring to bear all your intense focus and attention and everything that you've ever learned about being a lawyer and trying a case. You have to bring all that skill and focus to the front and the center for that period of time, with a goal that you're going to present the best possible trial you can. And that begins with the first question you ask in voir dire through the last word in your rebuttal, the closing argument. The goal is a perfect presentation of your case. And that means you don't want useless repetition. You don't want any evidence that's unnecessary. You don't want any witness that's unnecessary. You don't want a second of wasted time. You don't ever want to be caught asking the judge to give you a moment because you need to look up something or you need to check something. Everything that matters about the case should be on the tip of your tongue or a member of your team's tongue that's designated for that point. You should be the master of everything about that case, from the verbiage of the jury instructions to the contents of any order that applies to the case, to every allegation and every word of every document. It should be burnt into your brain. Your witnesses, their witnesses, their depositions, your depositions, their exhibits, your exhibits. You should know what you have in your trial at such a high level that you have no room for anything else. You know, tell your family, you'll check in with them each day at a specific time, check in with them. Tell the rest of the world to F off. And devote yourself to the idea of the perfect presentation of your client's case. And if you do that, then you will know when the case is over, regardless of the ultimate verdict, that you did everything you possibly could to get your client full justice. And I have won and lost plenty of cases in my career. And I can tell you that when I have lost, I've never had a client look at me and say, you could have done more. I might have lost, but I never left any doubt in my client's mind that I'd done everything that I could do to present the strongest possible case for them. I never let myself look like an idiot or a fool or someone who didn't know what they were doing, or that I was lost or incompetent, because the courtroom is a crucible. And if you're not prepared to do what it takes to be successful there, and that includes fanatical preparation, extreme commitment to knowing the case. If you're one of those people who wants to go to the courtroom for 8 hours and head to the bar for a nightcap and a drink and a steak and, 10 hours of sleep, don't do this. Don't. You're wasting your life and your client's time. Don't. You will get your teeth kicked in by people like me. It'll just be ugly. Just don't. Go do real estate closings or something. Don't walk in a courtroom unprepared. You will just get destroyed. I see it all the time on the other side. I always wonder what they're thinking. I don't care. I'm gonna smile and be polite, but I'm not gonna have any mercy. I'm gonna keep stepping until my client gets what they deserve, which is whatever that jury writes down on that piece of paper at the end of the trial. Not gonna meet them for drinks. Not gonna chit chat with them. Not going to a fancy dinner. Not doing anything but going right back to, the war room and going right back to work for the next day. That's all it is. When you're done, you should be spent. You should need a break. You should need a couple of days off. If you don't, hadn't done it right, sorry. If you got anything left when it's over, you hadn't put enough in. That's the level of effort it takes when you're planning and preparing to try the case. And if you're not prepared to make that commitment, co-counsel with somebody that is. Because there's not a worse feeling in the world than, a case not coming out the way you wanted it to, and going and looking at yourself in the mirror and saying, I could have done that differently. I don't ever be that person. Don't ever look in the mirror and say, if I hadn't have been so half-assed, that case could have been different. You're in the wrong place. Don't do that. If it's not worth doing 100, don't do it 1. Just don't do it. I understand you may have thousands of cases in your career, but your client in this case, they got this many. They'll never have another, most likely. And this one's life and death for them. So if you don't treat it like life and death for you, if you don't sell out, just don't start. They deserve better. And you'll end up an alcoholic, crazy, or suicidal if you're not willing to do what it takes. So just don't start down the road if you can't make the commitment to do it the right way. So, I know that's probably a little heavy, but this is heavy. For our clients, if we're in the courtroom, it means the defendants refuse to do justice, and it means we have to take it, and it is life or death. Whatever corporate defendants sitting at the other side of the table, they might have 1,000 other cases against them. But for our client, their life is tied up in what we do to get them justice. And again, for our clients, this is usually their one and only shot. And we better make sure we've done our part so we can look at ourselves in the mirror the next day and say, regardless of outcome, there was nothing else we could do to prepare to present the best case possible than the sacrifices we made to get ready and try this client's case. That's what it takes, an unwavering commitment to do it perfectly. You may never reach perfection, but you know when you look at yourself in the mirror whether you did all you could or not. And if you did even 1 ounce less than what was possible, you failed. Do it all or don't do it. Your client deserves nothing less. That's what you should strive for. Very heavy, sorry, but I get super intense about this because I've seen a lot of not intense and not serious lawyering where people just played around thinking that the defendant would eventually offer them some money, and then lo and behold, they were in the middle of a case, in the middle of a trial, and they didn't, and they lost. Don't be that person. Do it right. Thanks again for watching the video. Hope it's been helpful. Like and subscribe. We'll see you again soon with hopefully another useful lesson.